Yes, thank you. So first of all, I want to thank all the ones involved in the organization of this Theory of Animal Law conference, as well as the Anywhere project and University of Helsinki for hosting it. As she said, my name is Daria Vitale. I assist the Comparative Private Law Chair at the University of Geneva, and I'm the program leader for farm animal welfare at Animal Law Italia, which is a no-profit organization which brings together lawyers and professionals interested in animal protection law and policy, whose activity is mainly focused on advocacy, lobbying related to research, aiming to advance legal protection of animals in Italy and Europe. And I'm saying so to make you understand the background to the research we were involved into about ritual slaughter. And the topic I'm going to talk about today highlights itself for being characterized by a strong intersection between animal interests and human ones. Being the face of animals killing at the origin of criticalities directly impacting human rights and animal interest, in this case into a triadic shape that has to deal with multicultural shape of our society. And I hope I will make it more clear in following explanations. The legal scenario we have to set ourselves into is the European Union one, in which the ongoing debate about animal welfareism and regulation of exploitation of animals brought the European Union Commission to the ongoing revision process of the pieces of law providing the framework for animal production in EU husbandry practices. And whilst referring to the other phases of productions that are involved that involves animals, the minimum protection standards that has been identified in the last century as a balance between animal protection and food production interests lie on a common ground that see no key difference in husbandry regulation depending on cultural tradition. The phase of animal killing distinguishes itself being characterized by a dual regulatory system that directly depends on the multicultural character of our society, referring to two main categories of stakeholders to whom a different interest in terms of animal welfare at slaughter apparently refers. And I want to focus on the word apparently because what I will propose is an approach that takes into consideration also the interest of religious communities in animal welfare protection at slaughter. So, the assessment of this topic needs a multidisciplinary approach, and the presentation I'm going to introduce you today takes origin from a research project coordinated under the guidance of experts of these different disciplines, all related to the four key areas that have to be considered when dealing with animal welfare at slaughter. That's being ethic, science, freedom of religion, and consumer protection. Ethic, because the slaughter of animals brings with itself the need to consider the responsibility connected to husbandry practices and exploitation of animals for the sole interest of human beings. Science, being science because the assessment of animal welfare needs veterinarians and ethologists to be involved in any discussion dealing with animal welfare protection in order to assess how to shift from interests to rights based on a scientific ground and Religion, because ritual slaughter obviously is an expression of some religious community rights of practicing and observing religion's principle. And consumer, being unluckily animals involved in farming procedures intended to be consumed by humans. So, at this point I have to confess my personal interest for the way in which protecting human beings' interests and consumer interests in particular could set the path towards a better protection of animal welfare in a world in which I don't expect to see a short-term end to animal husbandry practices. This perspective brings us to considering the key aspects that we have to deal with when we talk about slaughter as commercial practice by an approach that at this point of our discussion needs to be neutral in order to guarantee us to avoid the risk of being influenced in our argumentation by our will to advance animal welfare and animal legal protection. And in relation to ritual slaughter, the interests the consumer is entitled with are different ones according to the portion of the market we take into consideration, being, for the purpose of this discussion, an interest defined as a value able to influence the choices that a consumer makes in relation to food consumption. With specific reference to the slaughter of animals, we could consider fate and animal welfare as the main interest that comes into play when considering the slaughter practices applied to the cut of meat the animal is transformed into, having a direct impact on the qualities of food, which could be relevant for the consumer in order to determine its choices related to food consumption. These two interests, meaning fate and animal welfare, are usually presented as opposed one to the other. Being the slaughter of animals without stunning, that is required from ritual slaughter procedures, proven by scientific literature to be less effective in protecting animal welfare, and thus assuming any attempt to conciliate these two interests intended for failure, because the main discussion is about the lack of possibility of put together animal welfare and slaughter without stunning. But what is ritual slaughter? These are the word. These are not the right slides, but it's fine anyway. The definition of ritual slaughter, defining ritual slaughter, limiting this definition to those killing practices that do not resort to prior stunning for their execution would be reductive and misleading. This operation would condition any attempt to reach the identification of balance between consideration of the needs in terms of animal welfare and the need to guarantee freedom of religion, starting from the assumption that the different positioning relating to the preventing stunning involves the radical irreconcilability of the two interests considered. Indeed, a concrete interest in the protection of animal welfare belongs both to the Islamic and the Jewish communities' interest in this practice, for which the death of the animals covers a moment of considerable importance. The word kosher and the word halal, which are the two main ritual slaughter procedures words related to, are related to what is permissible and admissible under the fate and how to indicate the conformity of a given food to religious prescriptions. These are not two terms, kosher and halal, that are completely overlapping in meaning, but both refers to a set of rules and prescriptions which, if respected, determine the suitability of the food for consumption by the believer who wants to conform to the precepts imposed by his own religion. I mean, neither the Jewish or the Islamic religious and legal tradition has any written text explicitly providing with examples of the way ritual slaughter has to be performed. This allows us to hope for the possibility of reconsidering ritual slaughter, even by those communities that are interested in practicing it, because if you look for the root of the ritual slaughter practice, you could, in both cases, find out that there is a link between the animal death and the need of the human being of feeling responsible for the life of that animal. And so ritual slaughters primarily serves as a way of sacralize animal death and of respecting the life of the living being that is being sacrificed to let a human being eat his flesh. Which are the main problems dealing with ritual slaughter and animal welfare? The key askings of both I have to be short, so I'm simplifying all the concepts. It's more detailed in respect of what I'm saying now, but just to give you the whole understanding. Animals, religious communities has a problem in applying slaughter, previous standing to ritual slaughter, depending on two main issues. One is the concept of integrity and health of the animal that has to be respected and assured in order for the animal to be suitable to be eaten by the religious community, and this brings to the problem caused by some techniques of stunning that are that could damage animals' health or integrity. But there is the possibility also to question what integrity is in the case of looking for a reconsideration of these problems. The other key issue is related to the religious need not to consume blood, usually being argued by religious community that ritual slaughter is the best way to bleed out an animal and to ensure a complete bleeding out of the flesh, since blood consumption is prohibited. Why? Because it represents animal life essence, and since religious communities wants to respect and to sacralize the death of the animal, the consumption of blood is prohibited. But this brings to the main criticality we will talk about as a solution to our problem, or at least one of the reasons we have to look for a solution, which is the high rate of inconsistencies between the practical way of slaughtering animals and the admission into the market of flesh derived from ritual slaughter procedures not being labeled. So, why do we have to think about mandatory stunning? Mainly because since the very first regulation of animal welfare protection at slaughter within the EU legal tradition, stunning has been considered as the best way to minimize animal pain, fear, distress related to the killing phase procedures. Although in compliance with the freedom of religion as established in the Charter of Fundamental Rights of the European Union and in implementation of Article 13 of the FEU, it must be respected the legislative or administrative provisions and customs of member states relating to religious rights. It must be also taken into consideration the welfare requirements of animals. And in order to provide animals with minimal protection requirements, ritual slaughter has been regulated to an extent which makes it acceptable to be performed. For this reason, ritual slaughter can be performed just in authorized slaughterhouses, and being mechanical restraints of animals mandatory in order to minimize animal suffering. But the question is, does this constitute a balance yet between animals' welfare and freedom of religion, or does this set down just the minimum standard that has to be respected in order for ritual slaughter without stunning not to be outlawed? The derogation that is admissible under European Union law is the derogation that is admissible under European Union law, which allows ritual slaughter to be performed without stunning, could be limited by member states. Article 26 of the Regulation 199 of 2009 allows member states to adopt national provisions aiming at ensuring greater protection of animals during killing, specifically in relation to the ritual slaughter procedures. Here comes the regional dimension and the reasons to reconsider animal slaughter without stunning as a practice that still needs to put in place an effective balance between animal welfare interest and freedom of religion. Consider that subsidiarity clause has been established in order to allow member states to take into consideration dimensions that goes beyond the purpose of directly protecting animal welfare at slaughter. We could ask ourselves if reconsideration would be possible, taking into account the development that the social perception of the importance to be attributed to animal suffering has undergone in the last century. Here comes the relevance of science, ethic, and consumer interest in assessing to which extent it would be possible to outline an effective balance between two interests that are just apparently opposed one to each other. Shifting from a dualistic approach, yes, I will go to an end, I'll try to. Let's keep it. The solution that has been adopted in European Union framework varies from the imposition of a previous stunning to imposition of contemporary, contextual, pre-cut or post-cut stunning. This is possible, obviously, under the legitimacy of the European Union regulation framework, which allows member states to introduce laws that better protect animals' welfare during ritual slaughter. What we assessed and what we proposed is if it is possible to extend this to the European Union legal framework, meaning that if an effective balance between animal welfare and religious interest has not yet been pursued by the application of Article 13 of TFEU and the balance with freedom of religion, there is still space to do so by understanding how consumer interest, meaning by consumer both religious communities' interest and consumer which are not intended to consume a ritual slaughtered animals product, could be looked into a comprehensive dimension, considering that what we have to think about, the key criticalities we have are determined by the admission into the market of flesh obtained by animals slaughtered without stunning, not being labeled, and not be given to ritual communities either a real information about animal stunning procedures and animal slaughtering procedures, thus being the interest of information to consumers, which is disciplined by mainly Regulation 178 and 1169, deals with the problem of consumer awareness, information to consumer, and the right to be informed about food choices, which could inform to ethical consideration, which could be both related to animal welfare and religious beliefs. And the need for a new balance has been assessed also by the European Court of Justice decisions dealing with the topic, which established how ritual slaughter without stunning is a key problem for animal welfare, outlawing the possibility to put together the organic logo and the halal logo onto products, and being the possibility of the introduction of a solution like reversible stunning, which is a way of stunning animals that is more respectful of freedom of religion, because it doesn't give problems in terms of animal health and animal integrity, could be a solution that is effective in both protecting animal welfare and freedom of religion. So we assessed that in Italy it would be possible to introduce such a provision, either by imposing reversible previous stunning procedures or a contextual or post-cut stunning procedure, being it necessary not in terms of animal welfare considered per se, but in terms of the interest of the consumer to have the possibility to conform its choices to its beliefs and to buy products that are fine for these needs and that could relate in a coherent way to his needs. So that's all. I had to short it down, but I hope it was clear.